morning. Please be seated. We are here for oral argument on State of Arizona versus the Honorable Marner / Haniffa, Rural Party in Interest. Our number CR 24-0300. A couple things for you, well, one thing really before you get started.
My phone on.
You have your phone off?
No, I thought you were going to say one thing before we get started is to turn your phone off.
No, but if anybody has their phone on, turn it off, including you.
As demonstrated.
You may keep whatever time you wish for rebuttal, but you have to keep your time yourself, and there is a clock at the podium for that purpose. So please begin.
Good morning. May it please the court, opposing counsel, my name is Ty Summers. I represent the state of Arizona through the Pima County Attorney's Office in this matter. I would like to try and reserve 3 minutes for rebuttal. This court should reverse the Court of Appeals decision in this case because the majority erred, not only by reading the individual sections of the luring statute separately, but also by not reading the luring statute in concert with the DCAC statute as required by the doctrine of in pari materia.
Ms. Summers, can I ask if you can pull the mic a little closer to you? I just want to make sure everybody can hear.
I'm so sorry. This court has made clear, most recently in State Farm and Serrato, that in pari materia is the primary tool of interpretation and that ambiguity is not a prerequisite to applying it. For over a decade, the question of whether DCAC sentencing applies to cases involving fictitious or putative minors has essentially plagued the punishment for those offenders that prey upon children. Carlisle, Villegas, Reginald, and then to Wright, the state's ability to hold this category of offenders properly accountable has been hampered. But in 2018, the legislature made their intent clear by adding what is now subsection S to the DCAC statute, that it is not a defense to a dangerous crime against children that the person is posing as a minor or otherwise fictitious.
Do we take anything from the fact that a few months ago the governor signed into law the amendment to 13705T and put in that same language, it looks like, from S, and now it's also under T? Is that pertinent to our analysis?
Well, it doesn't solve the question that's before you, because what is in front of you and what is affected right now is convictions from between 2018 to 2024, which is a significant period of time. And for SB 1585, unfortunately, if you review the history, the legislature was misinformed they were informed what the problem was, but not as the appropriate remedy to fix it, because the majority in Haniffa said the problem is with 133554. The amendment was to 13705. So it does not fix what the majority's error, or what the majority says the problem is. So unfortunately, it's now, in the state's opinion, superfluous language. And I think the only thing that you can take from that is that another reinforcement of the legislature's intent to punish this category of offenders. They had a problem brought to them. They did not get the right, or they were not given the right remedy, but they are still reinforcing, we want to do this. This is what we want to do. And unfortunately, it's imperfectly happened again. And I think that's the only thing that this court can take from that.
Well, couldn't we also take from it, too, or from the principle that the legislature is always free to modify and clarify statutes. Mm-hmm. But if they do that before we've interpreted a particular statute in question, well, that's their purview. They can do that. But that doesn't necessarily limit our ability to interpret a statute in its plain meaning prior to the amendment.
I would agree with you, Your Honor.
And also, pursuant to your argument, I think what you're trying to say is that we're not required to take it as a legislative concession that the Court of Appeals was correct in this case.
Absolutely. Absolutely. Again, so the 2018 amendment was supposed to solve the issue. And indeed, there are examples of courts determining that it had. The Lance was Division 1. Garner, which was unpublished, but that was Division 2. But the state now comes before you because the majority opinion of Division 2 has determined that it did not fix the issue. And again, since the time that this court granted review, we now have a division split. We filed the notice last week that in Division 1, McNulty agreed with the dissent in Haniffa.
What about the fact that Wright, the 2017 opinion, suggested some language in paragraph 17, I believe, and the legislature in the 2018 bill adopted some slightly different language. What do we make of that?
So what you should make of that is the way that I read that paragraph of Wright is that they were offering two suggestions. Here are two ways that you can fix this. You can say it's not a defense, like the offense statute does, or you can add or modify the definition of dangerous crime against children. And as both parties have discussed during this case, they started off with both, and at the end ended up with only subsection S. And we, of course, have differing views as to why the subsection T did not get modified, but it's our position, we can't speculate as to why it was removed. One thing that you can look to, though, is that when the bill was introduced, both in the House and then when it was introduced by Senator Farnsworth into the Senate, they were very clear that the point was to align the sentencing statute with the offense statute. And so subsection S, using the language, it is not a defense, mirrors the offense statutes, it is not a defense.
What about, I know there's been a lot of emphasis on the word defense, but going to the language in 133554B, which says it is not a defense to a prosecution for a violation of the section if the other person is not a minor. What about the term prosecution? I wonder, one, does prosecution take in not only the guilt phase but also the sentencing phase of a trial? And secondly, is there any definition anywhere of prosecution?
So we were able, I believe it is in the Attorney General's amicus brief, if I remember correctly. And the definition of prosecution that we were able to find was from an out-of-state case, 2 out-of-state cases. But that tells us that prosecution includes both the offense and the sentence.
And for sentencing phase, you have a prosecutor, you have a right to a defense, all during the sentencing phase, correct? Yeah, and so that's really the question. I mean, could subsection B, despite its placement before C, intend to include the entirety of a case before judgment?
It could. If you, again, if you are interpreting the word prosecution to apply to the whole prosecution, it could apply to the whole thing, which goes back to why we should not be separating out the 3 sections. We should be looking at them as a whole. And speaking of subsection B, so the Court of Appeals majority opinion seems to, subsection B is not a standalone crime, right? Subsection A tells you what the offense is, tells you what the object of the offense is, tells you the behavior that is the offense, and then subsection B tells you, and it's not a defense that it is a fictitious or putative minor, person posing as a minor. So essentially, you have to agree, and I believe the majority agrees, that subsection A covers both actual and fictitious minors, right? Again, subsection B is not a standalone offense. So if we agree that the term minor, the object of the offense, in subsection A includes both categories, then as you go down and get to subsection C, that term minor should still be applying to the same categories, to the same class of people. There's no distinction in subsection C. There's no distinction in subsection A. There's no distinction in subsection C. There's no exclusion. And so, again, reading everything as a whole, reading everything as a whole, the term minor in C should apply the same as the term minor in subsection A. Excuse me. And essentially, both the trial court and the majority in Division 2, they're inserting a new word into subsection C. They insert the word actual. The word actual is not there. It says the minor. The minor is referring back to subsection A. And I think Judge Eckerstrom, and the majority trivializes that the state is relying on just an article. But the choice of the word the is very important. It is a function word. It is referring back to the object of the offense. And in my brief, the state's brief, we provided a number of examples of other statutes where it's clear, and not just for sentencing, but for other portions as too, when it's saying the, it's referring back to the original object of the offense. Another point that the majority aired is determining the definition of minor. And so they look to the regular definition of minor, and then also from some of the history or the historical cases to say, you know, a minor is a person under 18 years of age. This is how we have construed it. This is how Wright has construed it. This is how it has been construed. It needs to be an actual minor. But again, you need to look at the entire context of the statute, and Polk helps us with that. And Polk teaches us that you can look at the entire context and determine that they intended to use a different definition of minor. And it does say in other statutes, unless the context otherwise requires. And there also with Polk, there's been a comment, you know, that Polk doesn't really help us because it says the luring statute and the child trafficking statute are materially different. That quote is taken out of context because the difference between the two that they were talking about there is that the child trafficking statute was deficient because you had a whole offense that had no classification, no sentencing. And that was the issue there. And when they were comparing it to luring, we don't have that problem there, right? It tells you luring is a class 3 and it's punished this way. And so that's how they were materially different. But what we can take from Polk is that if it's clear that within the statute they intend a different definition of minor, you can use the entire statute to infer a different definition of minor, and that's what you should do in the luring statute. Also, the majority relied upon Wright in terms of actual minor, and how Wright looked at the legislative history of the Dangerous Crimes Against Children statute, and how the intent has always been to actual minors. And I don't disagree, absolutely, that when it was introduced in the 80s, it was towards actual minors. But intent can evolve, technology evolves, and in this arena, it has evolved, and the legislature has made clear their intent to evolve along with it because, again, they keep trying now to include fictitious minors. And so
Counsel, let me ask you a question, though, about, I mean, the discussion of the intent of the statute in Wright was based upon the language of the statute at that time.
Correct.
Shouldn't the fact that the legislature actually followed this court's guidance or suggestion on how to change the language also then inform how we look at that statute today?
Yes, Your Honor. So, and that was another an issue that we had with the majority opinion is that they're using, you know, everything from Wright and basically kind of disregarding that the legislature responded to Wright. So I would agree with Your Honor there.
Under the majority's interpretation, if we were to adopt that, what function does subsection S serve?
None. Really, because the majority thought or said that associated subsection S with committing an offense, and declined to find that it was part of the sentencing, right? It says this is offense language, this is not sentencing language. Well, you don't need it in 705 because it's already in the offense statute. So now it's superfluous, there's no need for it. Also, I think the majority, I think it was actually Judge Eckerstrom, not the majority, I'll have to double check, getting to this proposition that it only applies to preparatory crimes, which does not, on its plain language, is not correct. All within the DCAC statute, they know how to separate between preparatory and completed crimes, first degree, second degree. And we get from Wright and from the plain language that a dangerous crime against children is a dangerous crime against children, first or second degree, completed and preparatory. So there's absolutely no language to support that it only applies to preparatory crimes.
I think he was taking that because it followed subsection R, which dealt with preparatory crimes, and somehow the placement, but are you aware of any authority that said, placement like that necessarily means that the next provision applies only to the prior provision?
I am not aware of any authority, and I cited some examples in, I believe, our original petition. We shouldn't read into the placement within the statute, because if you look historically, the definition, subsection T, has always been last. So anytime they want to add something new, they always add it right before the definition. And I did cite some examples in the past in my brief. And so we should not read into the placement of where it is.
Well, and if the placement matters, isn't it true then that subsection S is right before subsection T? I mean, if we were to get into the nuances of the placement, it strikes me that, S is right before T too. So, so anyway, I point that out as well, that the logical flow from R to S may not need to weigh into the calculation here.
I would agree, and I would stick with that it was just the logical next letter.
Yeah, I'm aware of the canon of the last antecedent, but I'm unaware of the preceding subsection canon.
Yes, Your Honor. Actually, it looks like I got a little over 3 minutes left, so if I may, I'd like to reserve the rest for rebuttal.
Thank you. Mr. Hamilton? This is not the clearest statutory scheme, so hopefully you can make sense of it for us.
Good morning. My name is Josh Hamilton. Ms. Lamoureux and I represent the real party in interest, Mr. Haniffa, who's present. Let me start by saying this. Luring a minor who is under 15 is a dangerous crime against children, a completed dangerous crime against children, and it is punished as such. Luring anyone or anything other than a minor who is under 15 is not a completed dangerous crime against children and is not punished as such.
Counsel, I'm going
Full
to
stop.
piggyback off the Vice Chief Justice's question. In the dissent stated that her colleagues, the majority's colleagues' interpretation of subsection S and T would nullify subsection S because there would be, quote, no scenario in which it could ever apply. I'm tending to agree with that. Tell me why I shouldn't.
I'm glad you brought that up, Your Honor, because that goes to a question that Justice Lopez asked. The state has made, and what I would submit as a false assertion, that subsection S, there's no scenario in which it would apply. But yet you have to use logic. Understand that in a scenario involving an actual minor under the age of 15, where the crime is completed, subsection S would be a non-issue. In a preparatory offense involving a real human being minor under the age of 15, subsection S would be a non-issue. Because the crime is not completed, it would be preparatory. And then you have a scenario involving fictitious minors, and that is what Wright was addressing, was solicitation and attempt type, preparatory offenses, inchoate offenses. And what the legislature did by enacting subsection S, and this is where it would apply to answer Your Honor's question, is it would apply in situations where the crime is not completed because of the impossibility for completion due to the fact that there is a fictitious minor.
And what's your authority for that?
Well, the authority comes from the Wright and the legislative fix in 2018 that came after it, but it also comes from logic, like I said. I mean, in a case involving actual minors, whether preparatory or completed, subsection S wouldn't really apply. So what the legislature was doing, and you look at the legislative intent behind subsection S, was they wanted to make sure that in those cases involving preparatory dangerous crimes against children, that there was some punishment, that it was the preparatory DCAC punishment, which is heightened, but nowhere near the, I mean, let's just be frank, that the penalties for dangerous crime against children are often akin, if not more severe than the penalties for murder.
Well, counsel, I want to pause you there because we hear that analogy a lot, and that's an invitation to increase the penalties for murder. It's not necessarily an invitation for us to discount what the legislature might be trying to do with dangerous crimes against children. If we use logic here, why can't we use the logic to say that the legislature, which has the authority to define crimes and punishments, wants to deter the underlying conduct associated with luring minors, and they don't care if it's an actual minor or not? Why can't we take that into account?
Because of the plain language of the statutes. And that is the plain language of subsection C of the luring statute. So going to the luring statute, subsection A defines the crime, and it's a offense that is, making a solicitation, knowing or having reason to know that the other person is a minor. That's how the crime is committed. Then subsection B explains that it is not a defense if that person is fictitious. And that goes right back to subsection A. In other words, it's the legislature enunciating that the crime is committed even in the absence of an actual minor. And the best evidence of a defense would be, how could I know or have reason to know there isn't even an actual minor involved in this case? And the legislature makes clear with subsection B that that is not a defense. Subsection C then sets forth, which is how criminal statutes are structured generally, subsection C sets forth the punishment structure. And it says that luring is a class 3 felony, and when it is committed against a minor who is under 15, it is punished as a dangerous crime against children.
Right, and so then from that, I go over to 13705, and I find that it's not a defense to a dangerous crime against children that a minor is, that it's otherwise fictitious. So why don't, in reading all of this together and reading the plain language of it, why don't I read that to then also evidence of the legislature's intent from the plain language there, that when you're applying the dangerous crimes against children sentencing statute, it doesn't matter if it was a fictitious minor?
A couple of reasons. The first is that reading would nullify the express language, the plain language, which is where this court's analysis starts and stops, frankly, in this case. The plain language of subsection C of the luring statute controls. That is the specific statute. The DCAC statute is the general statute. That's the plain language. The second reason is because, Your Honor...
And when you say the plain language, you mean the fact that it says luring a minor?
No, that it
the
means when committed against a minor who is under 15. That language means what it says. The state's interpretation is essentially an attempt to recast the meaning of the words under the guise of interpreting them. And that is not, this court's role in interpreting statutes is not to play mind reader. And I think this court should decline the invitation from the state to do so. If the legislature was intending what Justice Montgomery was suggesting is the reading of the law, which is that irrespective of whether there's an actual child involved who's under 15 or not, it is to be punished a certain way. They know how to use words and specify that, but they've not done that. And they've not done that despite invitations from this court and the lower courts repeatedly to do so. They've chosen not to. That matters. I think sometimes when interpreting statutes, what the legislature does not do is an important clue of what its intention was. And this is something that the legislature has not done. What the state is urging the court to do is basically grant a wish off its wish list that the legislature has heretofore not given them, which is to punish DCAC in cases involving fictitious minors.
Well, let's go back to what I asked Ms. Summers about ARS 3554B, which is really what we're talking about. What does it mean to have it says it is not a defense to the prosecution for a violation of this section. It doesn't say just subsection A, it's this whole section. I've always thought in terms of a prosecution goes from the charging all the way through the sentencing and the final judgment, and that the defense likewise goes through the entirety of the case. So the way that I read this, though, what you're saying is that no, that it's really just the defense to the guilt phase or the prosecution of the guilt phase, not the sentencing. So tell me why that is the way this should be read.
So a defense to prosecution is essentially where all the other elements of a statute are met. I can't be guilty, and that is a defense to prosecution. And the legislature is free to say that this is not a defense, and that's what they've done in subsection B. So essentially, to get to the heart of what Your Honor is asking, it precludes a defendant from saying, for example, to a jury, I can't be convicted of this offense because I didn't solicit or know or have a reason to know an actual minor. So because this case didn't involve an actual minor, and I need to be, you can't convict me of this. That is not allowed under that.
But aren't you still defending, whatever the defense is in the sentencing phase of the sentencing, aren't you defending against what the prosecution is asserting?
Yes, and I think to get to Your Honor's question, as you can imagine a trial in which there's a phase of the prosecution which the state is attempting to prove up its sentencing allegations, like a dangerous crime against children allegation, and they're saying that it is not a defense to that the case involves a fictitious minor. But to go back to the legislature has defined a completed DCAC as one that is committed against a minor who is under 15, and those words have meaning.
What's a little bit bothersome, to me at least, is that would give a different meaning to the word minor in subsection A than in subsection C, which is a pretty short statute to have two different views of what's encompassed by the term minor without a little bit more of a textual cue that the legislature intended a different meaning. Could you address that?
I would, and respectfully I would disagree with Your Honor's assertion, because if you look at subsection T, which defines what a DCAC is, it lists 23 offenses, and then it says when any of these offenses are committed against a minor who is under 15, it is punished as a completed DCAC offense, and then it calls for those enhanced penalties. But the reason that that's important is that the state's reading would essentially change the way we understand, the way the legislature has defined DCACs into something new. We look for punishment as to DCAC. We look at the age of the victim. It is a victim-oriented statute. And an example of that would be, there's strict liability for that.
Well, you're getting a little further afield, I think, from my actual question, which wasn't under 705, it's under 3554. So subsection A says a person commits luring a minor for sexual exploitation, and again, knowing the person is a minor. Would you agree that subsection B, because it makes it not a defense that the person is not actually a minor, if you have reason to know it, that minor in subsection A is someone posing as a minor?
I think it's saying commits luring a minor, the crime. But to punish a minor, the victim being a minor, that has to be a human being that exists in this existential plane that is chronologically aged less than 15 years.
And I guess that gets me back to what I'm trying to get at is that under your interpretation, it seems as if we're going to have a different view of what constitutes a minor under subsection A than what is a minor under subsection C. And that's the kind of disconnect that's at least bothering me. And I wonder if you know of any other statutes where you have something analogous to that, where the meaning of a single term changes without more of a textual cue that we want to change our meaning.
I think the textual cue is the reference in subsection C to the DCAC statute. And then when you look at DCAC statute, and it is in subsection T defining what DCACs are, which are not necessarily minor directed offenses. Like you can commit attempted first-degree murder. That doesn't have to be a crime committed against a minor, but when it is committed against a minor who's under 15, it's punishable as a DCAC. And what the state's suggested reading does, not only does it require this court to sort of judicially repeal the express language in subsection C of the luring statute and ignore the first part of subsection T1, the other problem that it does is it changes what a DCAC is, because now we're looking at essentially what the mindset is of the offender, and it would create a situation that frankly is absurd, because you can commit luring against a 15, 16, or 17-year-old minor. And under the state's reading, a case involving a fictitious minor where there's no victimization of a human being at all, that would be punished more severely than in a case involving an actual victim, an actual minor victim, 15, 16, or 17 years old. That would appear nowhere else in DCAC or the ARS. So if the legislature were to intend that in cases involving no minor at all, that it to be punished the same way as where an actual human child is affected and victimized and suffers the harm which goes to the underlying purpose behind DCAC, that would be something they would need to say. And so that's what the state's essentially, their thesis is, the legislature didn't really say what they meant, and they didn't really mean what they said. And you should trust me when I say what they really meant.
But doesn't the majority of the Court of Appeals say that 705S applies to preparatory offenses, so that it's no defense if it's not really a minor, but in preparatory offenses?
Correct.
So you're saying that, well, why would they want to punish that more severely as a preparatory offense when it's not a real minor?
More severely than just a Class 3 felony, for example. More severely than an ordinary class of felony, which, because preparatory DCAC has its own sentencing scheme in 705. But there's no suggestion whatsoever, and it would fly counter to the entire legislative purpose behind DCAC, to punish it the same as though it were completed against a real victim. 13705 is a victim-oriented offense, and in a case that doesn't involve a victim, the legislature may and has specified that we want some enhanced penalty to apply. But they've stopped short of saying we want the same punishment to apply as though it should. And there's been some comments from the state about, well, we don't have any tools to hold offenders accountable. Let's put the brakes on that. A person, according to 3554, who's guilty of luring is at a minimum guilty of a Class 3 felony that is prison only, that calls for mandatory sex offender registration for life. That is very different, though, than the real crime of luring to an actual minor, which causes real harm to a person they will carry for the rest of their lives. And in those scenarios, it is a very different punishment. But the idea that, like, offenders are being let off the hook or something is just a false premise that's not real, and I have to call that out.
But it sets up an oddity to me that outside the luring context, I was thinking of if we agreed that subsection S applies to preparatory offenses only. So if it's not a real minor, but it's preparatory offense, it's still going to be a dangerous crime against children. But if you completed an offense against a person who wasn't really a minor, you would be punished less harshly. And now that wouldn't come up, like, it's difficult to conceive that it coming up with luring, but one of the crimes, for example, is, manufacturing meth under circumstances that causes physical injury to a minor. So suppose you could have somebody that really says they're an adult, but they're really, you think they're a minor and they're not really,
Get
they're
their
an adult.
birthday wrong.
They're going to be punished less harshly, even though the offense is completed, manufacturing meth in the presence of that person as a fictitious minor, than if it had been a preparatory offense. It's kind of seems like a disconnect. Can you address that?
Well, I don't. See, I think you're putting the emphasis on the wrong thing. The punishment adheres where there is an actual victim who is victimized in that way under that statute, and then, if that's the case, then they're punished. It's punished as a DCAC, completed as called out by the legislature. If you had, for whatever reason, an uncompleted offense, then it would be punished as a preparatory offense. But nowhere in the ARS and nowhere in 13705 is there this concept that we look to the mindset of that's irrelevant. In fact, we know that from DCAC itself. I mean, a person who fully believes on all certainty that they are having sexual intercourse with an adult, and it turns out they're wrong, and the person is chronologically aged 14. They are subject to punishment as a DCAC. We don't say, well, hold on here. We look to the harm to the victim, and then that is what drives the punishment. And so what the state is calling for is something that's simply never been heretofore discussed or authorized by the legislature. And the fact
Counsel, let me ask you one question, though, because it seems that you're emphasizing that what the legislature is trying to do here is emphasize or focus on punishment for actual harm to the victim. But one of the purposes of our criminal statutes is deterrence as well. So why can't we take into account that maybe what the legislature has done here, which I would underscore, it seems to also be at the invitation of this court in both Wright and Mijak, in both of these areas, why couldn't the intent here be to deter and punish a preparatory offense or against a fictitious minor, because we don't want it to get to, the legislature in the state, wanting it to get to a point where an actual minor is harmed?
3 reasons. The first is because the plain language says what it says. We start there. Second reason is because the lower court's ruling harmonizes all the provisions that are implicated here and doesn't ignore anything. So it is, even if we had to look beyond the plain language, that's the proper reading. And then the final reason is because of the rule of lenity. If we really are here talking about, well, there's a couple of ways that this can be read, the outcome is the same. It has to be that ambiguity is resolved in favor of the accused. And I think that this is important because the rule of lenity has it's moored in the Constitution itself. When a statute is susceptible to more than one interpretation, the rule dictates the doubt being resolved in favor of the defendant. And I'll quote Justice Scalia because I think he said it far more poignantly than I ever could. And I quote, "This venerable rule not only vindicates the fundamental principle that no citizen should be held accountable for a violation of a statute whose commands are uncertain or subjected to punishment that is not clearly prescribed. The rule serves a long-standing principle in American jurisprudence, which is to reject the impulse to speculate about dubious or uncertain legislative intent. And probability is not a guide which a court, when construing a penal statute, can safely take." So I think
Not that I agree with him, but what case is that from?
Your Honor, it starts with an S, and it's from 2008. I read
We'll
so many
find it.
cases. I think it's Shalom.
We'll find it.
Yeah,
We'll find it.
it's 2008, Scalia, and it starts with an S.
Thank you.
So I'm running out of time, and so in closing, I'll leave the court with this. This court should reject the invitation to play the part of mind reader. If the legislature intended the law to work this way, the way the state suggests, they'll need to say so. They've not done that. The statutory language is clear. A DCAC is a specified crime committed against a minor who is under 15 years of age. Minor means minor. This case involved none. The lower court ruling should be affirmed. Thank you.
Thank you. Ms. Summers?
I have a question for you.
Okay.
Does the language of section T1 do anything for us here? Dangerous crime against children means any of the following that is committed against a minor who is under 15 years of age.
So
It's the committed against. I know in one of the many opinions we've looked at in this, one of the judges thought that verbiage had significance.
So I would go back to that adding something to, or changing the definition of T1 and also adding S is unnecessary. You don't need to say the same thing twice. And so because you can, again, defend against a sentencing allegation, then subsection S covers it. They did not need to change the language of T1. And two, let's see. I would remind the court that it was only Judge Eckerstrom that applied 705 to preparatory crimes only. The majority did not go that far. I would also remind this court that my opposing counsel framed luring as not a completed crime. Luring is a completed crime. This court has said so. I think you most recently said it in Marner. You said it way back in Mijak. And so it is a completed crime. There is no evidence that the legislature intended the 2018 amendment to only apply to preparatory offenses. Wright was the instigator of the change, But if you look at the actual materials, and right happened to be a preparatory crime because the offense was so old, luring didn't even exist yet, so they had to do the solicitation to commit molestation. So right was the instigator because after 2011, from Villegas and Reginald, the state could not apply DCAC to luring, so we had to rely on the preparatory, attempted sex conduct, et cetera. Wright then wiped that out because we no longer had Carlisle, and so Wright was the instigator to the change. That doesn't mean that it only applied to preparatory crimes, though. If you look at the materials, you can see the intent is we want to punish this category of offenders, and we no longer can do so. We don't have the attempts, we don't have the completed, and so let's fix this. Regarding the rule of lenity, Your Honor, or your court, this court should not get to the rule of lenity. That is last resort. Even if this court finds that the plain language is ambiguous, you still have legislative intent before you get to the rule of lenity, and the legislative intent all along has been absolutely clear for the past few years that they want to punish this type of offenders. The last thing I will leave is that my colleague emphasized no victimization of human beings at all. Justice Montgomery talked about deterrence, but I also want to throw out there as well that, thank goodness that there's not an actual child at the other end of this conversation and that it's the police. And there are scenarios, fewer scenarios, but there are scenarios when there is an actual child and then it gets intercepted by the parent or the police and takes over the conversation. And so they are the, quote, false or fictitious person, and they're going to fall under this category as well and not be punished. So we would ask that you vacate the Court of Appeals decision and hold that luring offense can be enhanced by DCAC, even if fictitious, and remand for further proceedings. Thank you.
Thank you. Thank both counsel for their argument today and their briefing on the issue. We'll take the matter under advisement and issue a ruling in due course. We stand adjourned for the day.